Do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or the Board of Pardons and Paroles, and that if you are sentenced to confinement in the Georgia Department of Corrections, no one can guarantee parole?
You can say yes.
Well,
She asked you, do you say that?
Oh, yes, yes, ma'am.
Parole.
Your Honor, may I allow Mr. Williams time to finish signing the indictment?
Okay.
Your Honor, with permission, may I approach with a member of Mr. Williams' team?
You may.
Thank you. Mr. Williams, do you understand that if, since your guilty plea is a blind plea or a non-negotiated plea, the state is making a recommendation of sentencing to the court? Notwithstanding the fact that this is a blind plea. You understand that, Mr. Williams?
Yes.
Okay. And Mr. Williams, were you aware of the state's previous offer that was turned down prior to your making this non-negotiated plea?
Yes.
All right. And Your Honor, at this time, the state is making a recommendation of 45 years with 25 to serve in custody, followed by 20 on probation. Subject to the...
All right, and do you want to break down for me what your recommended sentence on each count is?
Yes, Your Honor. The state is recommending on count 1, 5 years to serve. Count 56, 20 years to serve consecutively to count 1. Count 57, 5 years of probation to serve consecutively to count 6. Count 58, 10 years of probation to serve concurrently with count 57. Count 59, 5 years of probation to serve concurrently with count 57 and 58. Count 60, 5 years of probation concurrent with count 57, 58, and 59. Count 61, 5 years of probation consecutive to count 57. And count 62, 10 years of probation consecutive to count 61.
All right, thank you.
Mr. Williams, did you discuss the state's previous offer with your attorneys?
Yes.
Okay.
All right, and so we're all clear, we're talking about the same thing. Can you put what the state's previous offer was on the record for me, please?
I can, Your Honor.
Thank you.
The state's previous offer was a total of 43 years with 20 years, 5 years to serve on count 56, commuted to time served, followed by 15 years on probation. Years to serve in the Georgia Department of Corrections, consecutive to count 56. Count 59 was 3 years to serve in the Georgia Department of Corrections, consecutive to counts 56 and 58. Count 60 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, and 59. Count 61 was 5 years to serve in the Georgia Department of Corrections, consecutive to counts 56, 58, 59, and 60.
Was that the entirety of what the sentence was?
No, Your Honor,
I mean, I know
still
there were
reading.
special conditions, so y'all were
There
going
are.
to null pros,
We,
what,
yeah,
1
yeah.
and 62?
Yes, as the defendant agreeing to the special conditions that we asked the court to impose, the state was willing to null pros count 1, count 57, and count 62.
Okay, and then followed that consecutive to the probation. That was going to be what we call backloaded, and what were y'all proposing with regard to that, since it was going to follow the probated sentence?
The total sentence was 43 years to serve, with the first 5 years in prison commuted to time served, followed by 15 years on probation, followed by 23 years in prison, which would have been served in confinement, except that if defendant had complied with the special conditions of probation imposed as part of the sentence, the backloaded portion of defendant's sentence would have been commuted. However, should defendant had violated any special condition of probation within the first 15 years of his sentence, his probated sentence would have immediately been revoked, and he would have been required to serve the entire remainder of his sentence confined to the Georgia Department of Corrections.
All right, so as long as he had successfully completed his 15 years of probation, the 23 years that was going to follow it was going to be commuted to time served as long as his probation was successful. Is that right?
Yes, Your Honor.
Okay.
And the special, would the court like for us to?
No, I was really more interested in the length of sentence and what y'all had. I mean, I know you didn't reach agreement, but y'all, that's what the last offer had been, with, of course, a bunch of special conditions, which I guess is where the hang-up is. I don't know.
Right. Defendant did not agree to the special conditions.
All right. Is that basically your understanding too, Mr.
Yes,
Steele
Your Honor.
and
It would
Mr.
have been,
Adams?
yes, Your Honor. Mr. Williams would have been released today for 15 years on probation. If he successfully completes that probation, then he would not have to go to custody. If he did not, he faced probation revocation, as well as 23 years, as the court said, backloaded in the Georgia prison system. But we could not come to terms on all the conditions that the district attorney was insisting upon.
Okay. All right. Thank you. Go ahead, Ms. Love.
Okay. And Mr. Williams, were you aware of that previous offer as well as all of the requirements that that offer would have entailed?
Yes.
Okay. And had you had enough time to discuss that particular offer with your attorneys?
Yes.
All right.
Previous?
The previous offer.
Yes.
Do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge in this indictment? Do you understand that, Mr. Williams?
Yes.
Do you understand that if you enter into a non-negotiated plea, you do not have a right to withdraw your plea once the sentence has been announced?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
I'm not on probation.
Okay, so you're
Yeah,
not on
if you
probation.
were on probation,
Yes.
but if you're not, then it doesn't matter.
Okay. Do you understand that if you are placed on probation of any kind by this court, you cannot violate any criminal laws of any governmental unit or any special conditions of probations without being subject to revocation for the balance of the sentence the court imposes?
Yes, I know. I know.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, regardless of any advice by your attorney or anyone else?
Yes.
Do you understand that neither the court, your attorney, nor the district attorney's office has anything to do with parole, and the Department of Corrections or Board of Pardons and Paroles, and that no one can guarantee parole no matter what anyone has told you?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that, Mr. Williams?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or if you use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of up to 1 to 15 years in prison?
Yes.
Okay. Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to, that if you continued at trial, rather, you would continue to have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself? Do you understand all of those things?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury. Do you understand that?
Yes.
The right to remain silent and not incriminate yourself.
Yes.
The right to confront witnesses against you.
Yes.
The right to continued assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the continued trial of your case.
Yes.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proven beyond a reasonable doubt.
Yes.
The right to appeal if convicted of these charges after a trial. Do you understand?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
Well, Your Honor, may I interject?
You may.
Your Honor, on count 1, which is the racketeering conspiracy count, Mr. Williams is tendering a plea under nolo contendere. As to count 56, which is participation in a criminal street gang activity as being a leader or a supervisor or organizer, Mr. Williams is also tendering a plea to this honorable court under nolo contendere. The balance of the count, so he is tendering a guilty plea.
Your Honor,
Yes, ma'am.
would the court like to hear from the state or not?
About the NOLO issues?
Yes.
Sure.
Your Honor, the state asked that the court not accept a nolo plea and require either a guilty plea or a not guilty plea as to these charges.
All right. I'm going to permit a NOLO plea as to counts 1 and 56.
All right. Mr. Williams, as to count 57, participation in criminal street gang activity, how do you plead?
I plead guilty.
As to count 58, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
As to count 59, violation of the Georgia Controlled Substances Act, how do you plead?
Guilty.
How do you plead?
Guilty.
As to count 61, possession of a firearm during the commission of a felony, how do you plead?
Guilty.
And as to count 1, conspiracy to violate the Racketeer Influenced and Corrupt Organizations Act, how do you plead?
No law.
As to count 56, participation in criminal street gang activity under the leadership charge, how do you plead?
No law.
I think you didn't ask about count 62.
As to count, thank you, Your Honor. As to count 62, possession of a machine gun, how do you plead?
Guilty.
Are you pleading guilty to the offenses you have indicated because you are in fact guilty of these charges?
Yes.
All right. Are your guilty pleas and your NOLO pleas freely and voluntarily given with the full knowledge of the charges against you?
Yes.
Do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that you have only 4 years from today's date for a felony charge, and 12 months from today's date you don't have a misdemeanor charge, but to file a habeas corpus petition challenging the voluntariness and constitutionality of this guilty plea?
Yes.
Your Honor, also, do you...
You have
my-
30 days from
I was-
today to file a direct appeal from this guilty plea and until the end of this term of court to file a motion seeking to withdraw the guilty plea, which does not mean it would be granted, but that's the time period, okay?
What's a direct appeal?
Well, you can talk to your attorneys more about it, but it would be up to one of the, like the Court of Appeals, I think is where this one would go. Those are just the time periods.
And Your Honor, the state, in addition to the sentence we are asking that the court to impose,
Okay.
we would also be asking the court to require or to forfeit, have defendant forfeit all of the property that has been seized and that is currently being held, that was found or recovered or taken from his home after it was searched on May 9th.
Do you have any kind of list of what that property is? I mean, I'm not.
We
Not
do.
agreeing.
and that-
Oh, I know. I mean, I assume y'all aren't agreeing.
We're not agreeing.
You said it is a negotiated plea.
We're not. But we do have a list of the
All right.
property items.
Do you have it where available right now?
Yes. Actually, would the court permit us to send it electronically?
Sure,
Because
that's fine. And then if that is not imposed as a condition, is it just get litigated as like any forfeiture matter?
Yeah, it's
Yeah,
a
it
ci-
would be litigated
it's a
later
s-
on. Yes.
It's a civil separate filing
Okay.
in this court. It's not related to the criminal.
All right.
It's related case, but it's unrelated.
Understood.
And we are sending that to Your
All right.
Honor
Thank you.
at this time. And as it relates to the conditions of a conviction under 1615.4, Your Honor, we would ask, or as part of the sentence, defendant would be required to adhere to the requirements, the sentencing requirements of the gang statute, which at least in part require that he not associate with any gang members whatsoever. And I can read the rest of that into the record if the court requires, or I can continue with the factual basis.
All right, and let me ask you, because I know that at least while y'all were negotiating, one of the things that I guess was being negotiated was some exception for, I think, somebody that is contractually obligated on his record label. Is that something that the state would still be in agreement to?
No, Your Honor.
Okay, go ahead.
All right. Your Honor, as part of the requirements of 1615.4,
Yes.
defendant would, one moment, Your Honor. Under 1615.4, in addition to any other penalty provided by the code section, all sentences imposed under the code section shall require as a special condition of the sentence that the person shall not knowingly
Hold on
have.
just a tad, because there's a court reporter taking it down. And when we start reading, we read really fast. So go ahead.
This code section shall require as a special condition of the sentence that the person sentenced shall not knowingly have contact of any kind or character with any other member or associate of a criminal street gang, shall not participate in any criminal gang activity, and in cases involving a victim, shall not knowingly have contact of any kind or character with any such victim or any member of any such victim's family or household. So that is, and we've listed in our indictment the victims of the crimes, the overt acts that have been committed, and under the basic conspiracy law, those are the victims that we are naming. Your Honor, as this case has been tried and would continue to be tried until the state completed its in chief, the evidence has shown that the defendant, throughout the time between 2013 to 2022, conspired with both indicted and unindicted co-conspirators to participate in the enterprise known as Young Slime Life, or YSL, through a pattern of racketeering activity. Throughout that time, multiple conspirators, both indicted and unindicted, and including the defendant, have committed overt acts intended to further the enterprise itself. With regard to the defendant, as far back, the evidence has shown, as 2013, the defendant, along with other YSL founding members, Walter Murphy, for one, committed an aggravated assault and armed robbery against Derek Dotson. The court has heard evidence of that presented through Adrian Bean, who was a co-conspirator in that particular act. The armed robbery of an Archillian Bennett back in 2013. As alleged in the indictment, defendant and unindicted and indicted co-conspirators committed acts to further YSL that included drug sales, aggravated assault, and murder. They used and furthered, rather, this conspiracy by using social media posts and music to assert the violent nature of and the dominance of Young Slime Life, which is also known as YSL. The defendant is charged with being a leader of the gang YSL, and evidence has been presented by accomplices and co-founders of YSL, Trontavia Stevens and Walter Murphy, and evidence would have been that the defendant, as shown by some of his own social media postings, was the founder, one of the founders of YSL, along with Mr. Stevens and Mr. Murphy. YSL formed, according to the evidence that has come out in this trial, in 2012, 2013, under the former version of the name of the gang called Rock Crew, or Raised on Cleveland. The court has heard evidence of the 2014 and 2015 incidents that have involved conflicts between YSL members and IF gang members, that included someone shooting the window of Mr. Williams' car and armed individuals rushing outside during shootings at Club Crucial to ensure Mr. Williams, where armed individuals rushed to ensure Mr. Williams' safety. Shootings at Mr. Kelvin Watts committed by members of YSL. Communication with members of YSL after those incidents, and ultimately the murder of Donovan Thomas at the hands of members of YSL. The evidence has shown and will show that on January 10th of 2015, members of YSL drove a car rented by the defendant, a gray Infiniti, and drove past Mr. Thomas as he stood outside of a barber shop congregating with friends, and unloaded an array of bullets on Mr. Thomas, hitting him, his Chevrolet Tahoe, and two other persons in the process. Mr. Thomas died from those bullets. Phone records show that communication was held between Mr. Williams, Mr. Kelvin Treadwell, Mr. Demise McMullen, corroborating accomplice testimony that has been presented in this courtroom regarding what happened, who committed the murder, and what happened to the guns and the vehicles that were used in the murder. After the murder of Donovan Thomas Jr., the members of YSL responsible for the murder and members of YSL who were not responsible for the murder congregated at Mr. Williams' condominium called the Sky House, and they all made plans and later either drove or flew down to Miami. Prior factual acknowledgments by members of YSL include that Mr. Williams gave each of the persons who accompanied him to Miami money to lay low as they left the city following the murder of Mr. Thomas. The evidence has shown the ensuing conflict that occurred after Mr. Thomas was killed. It has shown shootings at Mr. Rashawn Bennett's home, shootings at Mr. Darren Mills' mother's home, and I said Mr. Rashawn Bennett's mother's home. Shootings unrelated to the conflict with members of IF gang, of a Lil Wayne tour bus. That shooting followed the confronting by Atlanta Police Department of members of YSL that drove to the compound where Lil Wayne was making an appearance and who drove there with the intent to disrupt and cause harm and to shoot up Lil Wayne's tour bus. Lil Wayne was another artist with whom Mr. Williams was having conflict, according to the testimony that had been presented. Mr. Williams had come out at that time with a mixtape that carried the name of an album that Mr. Carter was set to release, was not able to because his label would not allow that to happen. That caused a contractual or the threat of a lawsuit. It caused Mr. Williams angst. He posted about it. He said derogatory things about the persons who were threatening with the lawsuit. And as a result, he had to rename his mixtape to something different than what he initially intended. The person who ultimately was convicted of shooting that tour bus up, Jim, believe that recordings have come in regarding jail phone calls, rather, from Mr. Winfrey, and members of YSL regarding communication about getting a lawyer. Following the shootings that occurred in 2015, music, social media postings, and other overt acts were committed by Mr. Williams and other members of YSL, taunting members of groups that they considered opposition to YSL, posting of threats of violence by members of YSL against those people. Specifically, the music, Your Honor, contained lyrics such as the following: I rep my life for real, for slimes, you know I kill. I shoot at your mammy, need to stand down, take it to trial, pay for that casket, that's just if we whack them. YSL slimy and shady, watch me whack that bitch, pop them like assist, Glock with the assist. It also consisted of a song wherein Mr. Williams sang or rapped the lyrics. This is that slime shit, that YSL shit, killing 12 shit, fuck a jail shit. I'm in the VIP, I got the pistol on my hip, fuck the police. You praying that you live, I'm praying that I hit. This is slime shit. 100 rounds in a Tahoe, I'm prepared to take them down. Got banana clips for all these ends acting monkey. This is that slime shit. This is that mob shit. Fuck the judge, YSL. This that mob life. Williams released a video on YouTube of a song wherein he states, I shot at his mommy, now he no longer mentions me. Act like you want war and I'll smoke you like a blunt. Another song, I escaped every one of the licks because I was supposed to be rich. I don't care nothing about a cop. I'm just telling you how it is. I done did robbing, I done did the jacking, now I'm full rapping. Gave the lawyer close to $2 million, he handles all the killing. We don't speak about shit on wax, it's all my business. We know to kill the biggest cats of all kittens. In another song, I was on Cleveland, stuck like a magnet, bitch ass N-word, pay for that casket, that's just if we whack them. And yet another song, William, YSL won't fold, pick his ass off from the balcony, wipe his nose. I'm going to F for the cash, then she getting robbed by Tick, a reference to Trontavia Stevens. All I ever wanted was the money, put your hands in the air if you dare. F and N, put him in a wheelchair. And even later on, Mr. Williams, and I believe that this was in 2019, made a post to YFN Lucci or Rayshawn Bennett. If I ain't like what you do for your mother and kids, I would have been killed you. And in yet another song entitled Anybody, Defendant Williams stated, I never killed anybody, but I got something to do with that body. I got the streets on my back, carry it like I'm moving a body. I told them to shoot 100 rounds like he trying to movie the body. Ready for war like I'm Russia. I get all types of cash. I'm a general. As Mr. Williams' prominence in the music industry rose, his ascension within or in leadership in the gang YSL became more apparent as he rapped and talked about the crimes that YSL co-conspirators and members committed and how he got away with robberies. With respect to the Donovan Thomas murder, the court has heard evidence through phone records that within 6 minutes of the shooting of Donovan Thomas Jr., a phone call was made from Demise McMullen's cell phone to Defendant Williams' phone. And then immediately after that call, Mr. Williams calls his sister Dora Greer and then calls Kelvin Treadwell. There's then a series of calls between Dora Greer and Treadwell, and then Treadwell calls Demise McMullen or Nard. All of those calls happen within 15 minutes of the 911 call. And as I have stated before, the court has heard arguments about who committed the murder itself and what happened afterwards. The conflict between YSL and members of IFGA raps the lyrics that I referred to earlier. In May 2019, a YSL member shot multiple times at a vehicle owned by Rayshawn Bennett, a black and red Mercedes-Benz G-Wagon. At the time was being driven by a Milton Howard Jr. It was after that incident, later in August 2019, that Defendant Williams posted on his page the language YFN, if I ain't like what you do for your mother and kids, I would have been killed you. The post was then deleted from his account. Through text messages of a co-conspirator, Marquavius Huey, there was communication between Mr. Huey and Mr. Williams, both in January and in September of 2020. On January 19th, 2020, Mr. Williams sent a flyer to Marquavius Huey with the performance location of Rayshawn Bennett or YFN Lucci. And when he sent that, he sent it with the message, handle that tonight, SLAT, S-L-A-T-T. Mr. Huey responded, SLAT, S-L-A-T-T. On September 2nd, 2020, Mr. Huey sent a flyer to Mr. Williams with another performance location of YFN Lucci, and Mr. Williams responded, Slatty, that is S-L-A-T-T-Y, handle, and stay very low. Mr. Huey responded, flat, and for show, and appreciate you for everything, my brother. Never about money with me. I'm built on loyalty. Mr. Williams responded, slat, handle that. I got you. Through text messages and on a separate occasion, Mr. Huey said and conveyed to Mr. Williams that he would sit down for any one of them, and I believe that to be a reference of going to jail. When Mr. Bennett was not killed in 2022, Jaden Myrick sought permission from defendant Williams to stab Mr. Bennett while Mr. Bennett resided with Mr. Myrick at the jail. Mr. Myrick reached out to co-indictee Khalif Adams, who reached out to co-indictee Demikion Garlington to get permission from Mr. Williams. Demikion Garlington was also involved in the back and forth shootings back in 2015. On February 9th, 2022, Rashawn Bennett was stabbed by Jaden Myrick at the Fulton County Jail, and after that stabbing, Mr. Myrick reached out multiple times to Mr. Adams for some type of compensation for the stabbing. Mr. Adams reached out to Mr. Garlington about the payment for the completion. On February the 22nd, 2022, YSL co-conspirator and co-indictee Christian Eppinger called YSL co-conspirator Antonio Sumlin to get permission to finish what Mr. Myrick could not complete, that is the killing of Mr. Bennett. Mr. Eppinger asked for payment for a lawyer. However, these calls were intercepted and Mr. Bennett was relocated. In March 2022, information about the stabbing made the news, and shortly thereafter, a series of violent offenses occurred. On March 11, 2022, YSL associates Christian McMiller and Darius Ford were gunned down. Mr. McMiller is a childhood friend of Mr. Williams. Mr. Ford was also a friend of Mr. Williams. On March 12th, the day after, there was a shootout near the Cleveland Avenue area. A shooting by a YSL associate, Stephen Harris, in YFN territory occurred, and a YFN member was shot in the head. March 11th through March 14th, there were a number of social media posts going back and forth between members of YSL and YFN. One of them was a post by Shannon Stillwells. We ain't the only ones who ain't gonna be crying, that's going to be crying. After a posting was made by Mr. Watts picturing him, Mr. Shamel Drinks, and Mr. Jasper Walters, on March 14th, 2022, after YSL members spotted Mr. Drinks at a gas station and waited. Later, Mr. Stillwell tells Mr. Williams he has a new number. In my pocket, Mr. Williams responds, Mr. Huey saying, asking whether or not a lawyer was going to go and talk to another YSL associate, asking Mr. Williams to send him some money to pay his lawyer off. Mr. Williams asking Mr. Huey, who had been accused of armed robbery, what did he want? Mr. Huey responded with a number. After Mr. Williams stole a star ring from one of the victims in the indictment, he asked Mr. Williams, do you have a star ring? Mr. Williams said yes. Mr. Huey said, Slap, you can't cash at me $500 so I can make a payment to my lawyer. Mr. Williams responded, Slat. Mr. Huey sent him his phone number. Mr. Williams assured him through his throughout Mr. Huey's phone, you see messages of this nature between Mr. Huey and Mr. Williams.
with by a detective. The state vehemently accused me of lying to the jury, that the man never went, Mr. Bean was never taken to Grady Hospital, and that somehow I planted on him to say something on a recording where he said, the reason I implicated Jeffrey Williams is because the police told me that it would be easier for me. Then I had to go through the CAD reports and show that Mr. Bean was in fact taken to Grady Hospital, and Mr. Bean on recording told Detective Quinn, who of course told the truth, yes, when I spoke to the detective previously, I did lie. Then what the state doesn't tell the jury is that there's another man in the car. He is shot at the scene. He pled guilty. His name is Fred Prethro, P-R-E-T-H-O. And Mr. Prethro is in the Georgia State Prison System, easy to find. Mr. Prethro was in Grady Hospital also, unfortunately suffering from a gunshot wound. And you can hear the medical equipment behind him. And Detective Williams came in and was recording the whole conversation and said how many people were in the car. And Mr. Prethro names the people: Adrian Bean, who's the gentleman I just said, himself, and Walter Murphy. Are you sure there weren't a fourth person in the car? No, the three of us. The state doesn't call that person. The state does call Detective Williams. So I wanted to ask and inquire on that. The state, to obstruct, if that's obstruction, asked the predecessor court to prohibit me from getting into the fact of any conversation that would have impeached another witness. It's fine. Fred Prethro's on my witness list as well as the detective, and I have the recordings. In addition to that, Walter Murphy gave a statement while in the hospital, and his statement is very interesting. It's two different police reports, signed the same date, which is September 11th of 2013, and on the first 7 lines of the police report, they're identical. Then all of a sudden, when it gets to, on the right-hand police report, it says, Mr. Murphy stated that there were 3 people, I believe, I have to go back, in the vehicle. On the other police report, it states, Mr. Murphy stated there were 4 people. There's no reason that they should be different. They're both signed the same. The state doesn't call that officer at all. I tried to ask Mr. Murphy about it. The state objects, and the predecessor judge sustained the objection. Mr. Williams was not involved in the Mr. Dotson. Miss Bennett, that was Mother's Day, May 12, 2013. She reports allegedly an armed robbery. The detective who testified here and investigated stated he never took out arrest warrants for Mr. Williams. And he wrote in his police report, Miss Bennett is not truthful. That is the case that the state is talking about. The state then, there was Brady evidence that they don't turn over, and we find out about it in court after they arrest Miss Bennett because they say she's not cooperating, and it comes out that she told the prosecution over and over again that this did not happen the way that she reported it, and she doesn't remember. As to Donovan Thomas, and Mr. Williams has nothing but empathy, sympathy, and sorrow. They were friends. Lie. What happened here is the prosecution comes up with a theory because they need a motive, they think. I know you don't need a motive in reality to prove a murder case or any other case, but they wanted a motive. So they made it where Mr. Williams and a gentleman named Rich Homie Kwan, his name is Mr. Lamar, he's a performer, and Mr. Williams and Mr. Lamar were close. There are public documents, recordings, Mr. Lamar being interviewed almost every year, and then he talks about his time with this band or group called Rich Gang, and he says every year up to this past year, he, God forbid, died, we can't call him as a witness, how close he is to Mr. Williams. The state, though, made it in this case, or tried to make it, that Mr. Williams and Rich Homie Kwan are enemies because Rich Homie Kwan will not sign with a record label that has nothing to do with Mr. Williams. Mr. Williams doesn't sign to that record label. That record label is owned by a gentleman named Brian Williams, also goes by Birdman, wildly successful. He started Drake's career. He started Mr. Dwayne Carter, performer known as Lil Wayne's career. He started Nicki Minaj's career, just fabulous, powerful person, well-respected in the industry. But the state wants it to be that Donovan Thomas in interceded and would not let the reason that Jeffrey Williams had a feud and killed Donovan Thomas. Your Honor, what the evidence would really show if we kept going to trial, and I could tell you that Mr. Adams never thought we'd be in front of this honorable court. We always thought it would go all the way through trial. Was the state is saying that Rich Homie and Jeffrey Williams don't speak since the fall, and they have a bad relationship the fall of 2014. We would have shown, and we served on December 15th, 2014, Jeffrey Williams in a private plane with Mr. Lamar or Rich Homie, and they are high-fiving and laughing with each other. That is on audio video. There's a man who the state hasn't called yet, Mr. Martinez Arnold, also known as Duke, is on that plane as well. He would have identified the item, and he would have testified that Mr. Williams and Mr. Lamar were very close in December 2014. Then on December 29th of 2014, Mr. Williams, Mr. Rich Homie, Mr. Arnold, others were at Brian Williams' home in Miami, Florida. There was a posting by Mr. Lamar, Rich Homie, and a picture of Mr. Arnold and Mr. Lamar, and they said, Mr. Lamar says, "This is my #1 man, Duke," or something to that effect. We would have put that into evidence. In addition to that, Your Honor, on December 8th, 2 days before Mr. Thomas, God forbid, was killed, Mr. Williams is with Mr. Thomas, as well as Mr. Sledge and Brian Williams in Brian Williams' tour bus outside of a fabulous entertainer, artist, Mr. Clifford Harris, T.I.'s studio, and at that time, they were very close. But you also have the detective with the gang unit, Detective Underwood. I asked her within the last 2 weeks or 3 weeks, did you do any, and she was on the gang unit the entire time, including today. And I asked her, do you have any evidence about Mr. Williams and Mr. Thomas being close friends? And she said, yes, of course I knew that. I said, how about in January of 2015, close to the time of Mr. Thomas's death? She said, yes, they were close friends. Mr. Michael Sprinkle, he's a deputy district attorney in the Fulton County DA's office. He had a recording with Mr. Treadwell. You've heard the name O.G. Bentley. And in that, they're going through the evidence. And Mr. Treadwell, it's important because he has a child, too, actually, with Mr. Thomas's sister. So he's family. And Mr. Sprinkle states, this is 2018, this is after the rental car, this is after all of the interviews of Mr. Copeland, this is after the interviews of Mr. Zachary. Mr. Sprinkle's in some of those interviews with Mr. Zachary. Mr. Sprinkle on tape, on recording, states, I do not know why anybody thinks Jeffrey Williams is involved in this killing. He and Donovan Thomas were close friends. It makes no sense to anyone. And Mr. Williams was never arrested, never charged, even in this, as the court just noted, with anything to do with Donovan Thomas's, God forbid, killing. In addition to that, with a group of people on Auburn Avenue, Jeffrey Williams performed and did a music shoot there to try to help other people who are suffering in poverty to get out and to be able to be seen and to broadcast their music. Jeffrey Williams does that for everybody because he comes, Your Honor, from the struggle of total poverty, seeing people killed. He saw his brother die right in front of him, and law enforcement, I'm not blaming anybody, everybody's on edge, but law enforcement would not get any help for him because there are all these people around. It is just, what Mr. Williams has gone through is wrong for everyone. It's not just Mr. Williams, it's that whole community, but he's trying to get people out of poverty and out of that community. I have been with Mr. Williams, where we have got to speak with children together, and he tells them, don't be a rapper. Be like Brian, be a lawyer, keep in school. He tells his children, get your education. His family, his whole being, Your Honor, trying to break the chains of poverty for others, and it has been spun in this courtroom with false statements and allegations against Mr. Williams at every turn. In addition to that, Your Honor, the state talks about the fact that Mr. Williams takes people to Miami. You would have heard evidence if we went forward. I put all these people on my witness list. Not one person on my witness list has been interviewed by law enforcement or the prosecution. They have investigated this case for 15 years. They haven't interviewed all these people. That Sprinter van that you heard about, that was already booked days before. Going to Miami, Florida, Mr. Williams and Mr. Brian Birdman Williams, they did a video shoot for a music video. If anybody would have gone further with the expert for the state, they would have seen that Mr. Williams' cell phone does not contact any of the co-defendants that are named here in Miami, and Mr. Williams stays at a separate location than any of those persons. He would always take people who can't afford it on airplanes, on buses, on tours, to his concerts. He let everyone go because, Your Honor, they never left that area. He wanted to show people you have an opportunity. The world is big. Mr. Williams gave jobs to everybody who'd want to work. He'd give them jobs and security. And I'm not insulting them. They really weren't their jobs, but they were being mentored, but they were given titles and tried to give them respect and opportunity. But if they did not wish to work, Mr. Williams would not allow them to work with them. This has all been turned on its head by the state. The fact that the state has put in Mr. Williams' lyrics are offensive recordings. On this list, we are bringing in all of his people, his recording artists, his engineers, his managers, his record label, and an expert, the Honorable Dr. Eric Nielsen, to talk about how Mr. Williams creates his music. His music is then changed around and merged. Mr. Williams, some of the lyrics you just heard are not even uttered by Mr. Williams. The state has no idea when these lyrics were made. Some of them were made before the shooting of Donovan Thomas, that the state is saying this applies to the Donovan Thomas killing with the Tahoe. They are so far afield of where we need to be when we are trying to, God forbid, take somebody's liberty, Your Honor. The state is talking about, said by Mr. Williams, but they don't care to find out. They are on a tunnel vision to try to convict a man who should not be convicted. The statement about, I never killed nobody, but I got something to do with that body. If the state just bothered to talk with anybody, that is a Nicki Minaj song with Jeffrey Williams. It is written by Nicki Minaj. That is on the text messages I gave, not the text message, the Instagram or Twitter rather, that I gave to the state. That is out well before this, but the state doesn't care. This is out in 2015 or 16 or 17 or 18, I can't remember, I think 18, where Mr. Williams was asked who wrote anybody, and his response is anybody was written by Nicki Minaj, and it was. But it was really written and sung. It's a takeoff of a song by Tupac. There's a song that it parallels, which is an inspiration. But here we are with the state. Also, never killed nobody, but I got something to do with the body. The next line comes up is, it's a truancy body. The state can't explain that, so they just conveniently leave it out. Your Honor, there were wiretaps on this case. Mr. Williams, it was going to come out, there was an application to wiretap his phone. The state never presented to a judge. That speaks volumes. The leader of the YSL criminal street gang, who's been involved from 2012 until his arrest, and even according to the state, while we sit here, they never even tried to wiretap his phone. It might have been because they don't really know what his phone number is. So all these communications you're being told about with Mr. Huey, I'm not so sure the state could have gotten anybody to say that's Mr. Williams' phone. This is how the trial has gone for us. But we sit here for almost 2 years since we did our jury selection initiation on January 4th, 2023. Mr. Williams has been sitting in a jail since May 9th, 2022. This is 2.5 years waiting for the conclusion of the state's case, verdict from the jury, and that's why he is tendering this plea. I'm telling the court this, and the court knows when you came out the first time, this is very hard for Mr. Williams. I am not supportive of what we're doing right now. I'm not against it. But I told Mr. Williams, you okay with me saying this? Yes. I told Mr. Williams that I think we're winning the trial and we should go to verdict. But he told me I can't wait another 3 months if there is any possibility I could go home because I have children that are hurting. I have things to do, and he has some medical issues that he would like to tend to. He eats out of a bag, Your Honor. He eats processed food only. He gained 75 pounds during trial. He's lost it since. But it is hard. You know, for me, it's only 3 more months. It's enjoyable, actually. I enjoy coming. It's not that enjoyable for Mr. Williams. He told me he wakes up. Can I say this? Yes. He wakes up every day, and it's another day in HE blank blank. Your Honor, the state is talking about, in this case, they put in social media. This honorable court was not here, but the state put in that Mr. Williams, in the indictment, Mr. Williams, $4 million murder for hire on a person's head. That is a lot of money, and that is awful. If they would have read the chat, the Instagram chat, Mr. Williams, above it, there's a picture of a very well-known, very accomplished musical artist who actually had surgically implanted in his forehead a pink diamond worth $24 million that day. That's what Mr. Williams would talk about. That's the type of evidence that is coming from Georgia in this case. It is wrong. This is all wrong. And I know we're pleading guilty, and I know we're pleading nolo, and I know we're asking this honorable court for a certain sentence, and we'll get to it with the court's permission. But this is the type of evidence that there is. But it is holding this man hostage. And that's not really what we're supposed to do district attorney time in the state of Georgia or anywhere. The state then, because I opened on that, then they never bothered to put in all of the chats. Why did it take me to read the chats? In addition to that, going back to Donovan Thomas, talk about Mr. Williams involved, the state did a geofence. A geofence tracks his devices. It doesn't have to be a phone. It could be an iPad. It could be any type of electronic device that targets and is used. You don't have to be on the phone. It's the contact. If he has an app open, it'll capture it. And the state targeted the McDonald's, where they keep saying that Mr. Williams met with people there. They targeted the barbershop where, God forbid, the killing occurred. And they targeted a third location, no, 2 locations. And it comes out, Mr. Williams' devices are not there. It's exculpatory. I don't get that information. I got that because I interviewed Lieutenant Crabtree, and the results can't be found, according to prosecutors. I did a motion for that. They just can't find it. That is great evidence for Mr. Williams. It would have also shown clearly that when he does go down from his house after getting this call that I'll talk about from Demise McMullen, he's not with these other people. And the expert for the state, the FBI agent who does the telephone analysis, Mr. Williams' phone does not ping off the same tower as a Demise McMullen or a Mr. Copeland or a Mr. Garlington or whomever. The state of Georgia has misrepresented for 2 years in front of this jury. They have hidden evidence. They have violated Brady. They have falsely accused Mr. Williams. Your Honor, saying that Mr. Williams gets that call 7 minutes after, the state said 6, it was 7 minutes after the killing of Donovan Thomas from Demise McMullen. Mr. Williams was already out of his home. Mr. DeMise McMullen's calling Mr. Williams. He's not even there. He's going down to meet with Mr. Kelvin Treadwell, also known as O.G. Bentley. O.G. Bentley was supposed to go to Miami, Florida. They were talking about this deal. And Mr. Williams, that day, he was given another contract. Mr. Williams, by this time, he went from zero money. He is a multimillionaire at the time. He doesn't need the Cleveland Avenue drug deals for $15. He doesn't need the shootings. He wasn't even living in Atlanta since 2018, 19, 20, 21. He came back the very end of 21, 6 months, and he got arrested in May of 2022. In his house, Your Honor, we have everyone on the witness list. There are 12 people in that house. Mr. Williams opens up any of a car that he has. He'll rent cars for people. Any home he has, he will allow people to live in hotels because people that he knows, unfortunately, are homeless. And he gives them all places to stay, cars to drive around. He is not involved in criminal activity. Mr. Williams just got back in our country. His passport shows it. Right before he was arrested on May 9th of 2022, there were other people in that house with the drugs and the guns. There were people whose the guns are in their names. They were going to come in court and claim the guns. Everybody else was doing as well, but Mr. Williams has entered a guilty plea. I'm not going back on that, but I just want you to know that this case is just wrong to do to somebody with no bond and to hold him hostage. He wants to, you may not do it. He's aware of that. He's aware of that. But the state offered him 15 years on probation, but they keep piling on these conditions. He just said, he made up his mind. He said, I'm just going to go with it. I got to get home. Judge may not let me home, but I'm not doing these conditions and admit that I'm the leader and I'm involved in the killing and my music just promoted everybody to do it. He's not going to do that. So he did not do that. And that's how we wound up here. The state, the night of the killing, people came to Mr. Williams' home. The state tells the court, he said, lay low. What they don't tell you is right after that, he gave money to Mr. Sledge, who said, they're going to kill me. They think I did it. And Mr. Williams said, if you had anything to do with it, I don't want to be with you. And Mr. Sledge said, I just need a hotel room with my children and my bride or my significant other to get to. And Mr. Williams said, be safe, lay low. That's the lay low. In addition to that, Mr. Williams told Mr. Copeland's with the police. Hours after the killing of Mr. Don Thomas, Mr. Copeland goes to the police department. Mr. Williams is the person who told him to go. Mr. Copeland said, what do I do? They're shooting at my house, at my family's house, at my significant other's mother's house. And Mr. Williams said, if you had anything to do with the murder, get out of here. Mr. Copeland denied it. And Mr. Williams said, then go tell the police. Mr. Copeland said, you want me to go to the police? And Mr. Williams said, if you had nothing to do with it, they think you did it. Go to the police. In addition to that, Mr. Copeland said, well, I'm going to retaliate. Mr. Williams told him, don't do that. Let 12 handle. That's on recordings. That is on recordings on January 11th of 2015 with Detective Thorpe. Your Honor, as far as Wayne Carter, a performer known as Lil Wayne, Mr. Williams had no conflict with him. They are friends. We were presenting evidence that right before this shooting of the tour bus is April 26th of 2015. Mr. Williams is performing in New Orleans area. And that's the area where it's Holly Grove, where Mr. Carter, or Lil Wayne, a performer known as Lil Wayne, comes from. And in order to drum up popularity and interest, people get on the internet and they start what's called rap battles, arguments, feuds. That's what happened here, and you would have heard testimony from Mr. Williams' management that they said, start a rap battle. It'll be better for your career. Mr. Dwayne Carter is aware of that. Mr. Dwayne Carter's interviewed. The state's aware of this. He has interviews after this. Are you mad? What's the real deal with Jeffrey Williams? He states, no, he's great with me. He brought popularity to me. He loves me. He idolizes me, and I love working with him. They did an album together. In 2014, they're in the studio together, making music together. It is all made up that Mr. Williams is involved. Mr. Williams gives a statement. The state refuses to put it in and then stopped me, the previous judge, from cross-examining the detective. His name is Racy. He met with Mr. Williams in the DeKalb County Jail on the 15th day of July 2015. Mr. Williams is arrested that day. And there's a long interview. And Mr. Williams waives his right to counsel. He tells them, I'm his lawyer. They say, you don't want to speak to us? You don't have to. He said, well, I'll speak with you. And they asked Mr. Williams these questions. What about Lil Wayne's shooting? He said, it was outrageous. I love him. That's my idol. I love Lil Wayne. How about this battle? He says it's promotion. They asked him about his rap lyrics. It's the only person that the state ever did anything about rap lyrics with. And they asked Mr. Williams, what about the rap lyrics? And he tells them, it's hyperbole. He didn't use that word. He used the word, it's made up. It's rhyming. It's made up. Not like the state is saying that I rap lyrics for real. That's not even Mr. Williams' utterance. Your Honor, the point I'm trying to make to you is what the state of Georgia has presented to this jury in this courtroom the past year has been full of untruths. And they know it. The state says that Mr. Williams had a conflict because he named an album with Dwayne Carter, and Dwayne Carter didn't like that. Dwayne Carter's interviewed. He said, that was one of the thing anyone could have done to me. It shows how much he really appreciates me. It shows respect and honor, and I appreciate what he did. The state knows this. With regards to Jimmy Winfrey, what the state did is they put in a recording. It's not Mr. Williams. It's a jail recording, Mr. Winfrey and an unknown person. And an unknown person says, when you get out, you're going to get a Porsche and $250,000. Mr. Williams not privy to that. The state looked at all of Mr. Williams' bank records, everything. They undressed him financially. There's zero evidence Mr. Williams did anything for Mr. Winfrey. The state tells you that Mr. Winfrey asked for money for a lawyer. The conversation was, and it's recorded, it was with Mr. Williams' manager. And Jimmy Winfrey said, I need to show that I was gainfully employed for the court. Can you get me something from YSL? And the manager said, yeah, if we have it, and if it's true, yes, you can have it. That is it. There's no evidence that Mr. Williams paid for anybody's lawyer, Mr. Winfrey or otherwise. In addition to that, Your Honor, the social media postings with Mr. Rashawn Bennett, also known as YFN Lucy. So Mr. Williams, the state tells Mr. Bennett on social media, I would have killed you if I didn't like the way that is the post. What they don't tell you is Mr. Bennett, who is also, to his credit, trying to drum up his career. Mr. Bennett is picking on Mr. Williams, who's a much higher profile. Bennett is saying that he slept with Mr. Williams' fiance while Mr. Williams and she are a significant couple, that Mr. Williams' music is awful. Nobody should listen to his music ever. Mr. Williams responds by saying, we can do an album together if you want. Stop this. The man continues of how he's sleeping with Mr. Williams' significant other, and then Mr. Williams responds by saying, they don't tell you about. And Mr. Williams did nothing to Mr. Bennett. In fact, the evidence would have shown, if we had time or we would have gone forward, that Mr. Bennett and Mr. Williams are on the red carpet receiving awards in California, sitting right next to each other and taking photographs. This is not the Jeffrey Williams. Jeffrey Williams is a known person who is all over the place. If he did something, somebody wanted him, they can find him. This is not he's not hanging out on Cleveland Avenue. What the state is saying are not true. The situation with Mr. Bennett, so he's in the Fulton County Jail, and he's housed, and there are crazy, sick, violent people, and they're on the phone, and Mr. Myrick, M-Y-R-I-C, is calling other people, supposed co-conspirators. How much will Jeffrey Williams give? He doesn't say that, but that's the theme of it, as well as Christian Eppinger. What the state doesn't tell you is that when Mrs. Sumlin is asked, hey, find out how much Thug will pay me to kill Mr. YFN Lucci, Mr. Sumlin says, I don't know his number. I can't get in touch with him. He doesn't talk to me. And that's because, Your Honor, since 2015, and he means no insult, but Jeffrey Williams has had zero contact with Shannon Stillwell until this case, Kenneth Copeland, Demikian Garlington, Justin Cobb, Demise McMullen, Mr. Sledge, Mr. Murphy, all these people. This is a lie. This is a 100% lie, and that's why we tendered a NOLO plea to being a leader of a criminal street gang. Mr. Williams is not a leader. In fact, if it would go forward, on Mr. Huey's phone, there are conversations with Mr. Copeland. And they both say how Jeffrey Williams is a zero, and F him. And they don't talk to him, and Jeffrey Williams never does anything for them. Mr. Huey, Mr. Williams met later. He met him closer in the time of 2020. Mr. Huey's father went through a horrible episode that Mr. Williams knew, and that's how Mr. Williams knew his son, who's Mr. Huey. And Mr. Huey's on hard times, and Mr. Huey's making mistakes. And Mr. Huey, supposedly, Mr. Williams believes, armed robbed a man named Chandler Durham, D-U-R-H-A-M. Mr. Durham, record engineer. And Mr. Williams states, give him back, tell him to give back the property or he's going to die. The state puts that as an overt act. No one dies, and the property doesn't get returned. Mr. Huey ignores Mr. Williams. The state told you today that Jeffrey Williams sent Mr. Huey a posting that Mr. YFN Lucci is going to be performing on January 19, 2020. That's not true. Mr. Huey sent that to whoever phone it was. And all it says is slat and slatty. Well, I went out to the places that Mr. Bennett was supposed to perform. There's no shooting. There was no fight. There was nothing to report. There's nothing here. In addition, the state says the same thing on September 12th. Jeffrey Williams even having a conversation with him. But even if it was, it doesn't show anything. It says slatty, lay low. Lay low means don't do anything. Get out of the way. That is what it is. That is Mr. Williams' role. Mr. Williams, there is evidence in the record, and there would have been more. He takes people on tour with him. He takes people in the mall with him. But when they do crime or do things to people, for instance, there was a prostitute, and several people gave that prostitute money, $500. And the prostitute, at the end of the $500, getting $500 from several people, had sex with a person, and then she was armed robbed. So all the money came back. Mr. Williams wasn't involved in that, but he heard about it. He made those people find the prostitute and repaid her every dime. People stole from stores that Mr. Williams found about. He went to the stores and he repaid all that. He didn't steal anything. He doesn't need to steal anything. Your Honor, Mr. Williams stands with the John Lennon. Mr. Williams is unbelievable talent. He's not just a rap artist. In fact, when he's interviewed in 2017, he gives a statement and he says, I had to learn rap. He grew up in a house learning other forms of music. He likes all music, but rap hit in his community, and his community raised him, supported him. They came out to him. They made him get into establishments, and once the establishment saw all the people come out, he got more establishments. And then he went out of that little area in Atlanta to other parts of Georgia and then to all the neighboring states and throughout our country. And he has performed on every continent but one. He has performed in front of, being the headliner, 300,000 people at one time. He has a real life and career. He is not the leader, and he is not worried about buying jewelry that is stolen. Mr. Williams is actually innocent. I'm not trying to corrupt our plea. That's his plea, and he's entitled to it, and he wants it, and he embraces it. But to me, this is a wrongful prosecution. This is outrageous.
All right. So you're pleading guilty, or your client is pleading guilty to counts 57 through 62.
It's all true.
Do you
Yes, there's a
concede
factual
there's
basis.
a factual basis
I
for
concede,
those counts?
yes, I concede that.
Okay. All right, I didn't mean to interrupt you.
No, it's fine. And Your Honor, I'll answer any of your questions, but the point I'm trying to make is 45 years to serve 25 years in prison, when just this morning it was a probationary offer. It was a probationary offer. The state knows, but they want to control. They have this theory of music, and they want to stop Mr. Williams from making music, from entertaining, just stop his life. That's just not right. And it's wrong of the district attorney in Fulton County to do that. If they offer probation, then he's not a 45 to serve 25 years in custody type of person, and he's certainly not the person that the state has stated in front of the court. What we're asking, Your Honor, on count one, which is the RICO count, to accept the nolo contendere plea. Please sentence Mr. Williams to 20 years to serve 5 years in prison commuted to time served. Mr. Williams has served, as I said, 22.5 years. On count 56, Your Honor, that's the leadership of a gang, nolo plea, 20 years to serve 5 years commuted to time served, consecutive to all other counts. On count 57, which is a gang count, Your Honor, not a leader, guilty plea, 20 years to serve 5 years commuted to time served, concurrent with count one. With regard to count 58, which is possession of, I believe it is marijuana with intent to distribute, 10-year sentence on probation, concurrent with count one. On count 59, which is violation of Georgia Controlled Substance Act, possession of codeine with intent to distribute, 5 years on probation, concurrent with count one. On count 59, Your Honor, which is violation of Georgia Controlled Substance Act, possession of cocaine, 3 years on probation, concurrent with count one. Count 61, 5 years of probation. It's a firearm count. Before count 56. And then count 62, 10 years to serve commuted to time served. That should be a total sentence, Your Honor, that we are respectfully requesting to consider. I believe it's 45 years to serve 5 years in prison, commuted to time served, 40 years on probation, credit for the time already served and community time served. As I said, after 3 years of probation, the probation becomes non-reporting, and after successful completion of 10 years on probation, the balance of the sentence be terminated. Mr. Williams asked the court for house arrest for 3 years as part of the sentence. House arrest specifically defined that Mr. Williams will be in his home or at any lawful employment, touring, studio, performance, business meetings, and the like. Wear an ankle monitor for the first year and pay the costs of the same, and the company must be approved by probation department, and the ankle monitor to be affixed within 10 days of hopeful release from custody. Mr. Williams cannot possess a firearm, but he can be around licensed security who are armed or other persons who are lawfully carrying a firearm with a license, and that would be knowingly for Mr. Williams. Mr. Williams can transfer probation outside the state of Georgia. He has residences in the state of California. He has studios in the state of California. Mr. Williams be allowed to travel throughout our country and the world for lawful work-related industries. Mr. Williams wants to perform. He's going to do this anyway, Your Honor, but we made it part. At least one concert each year at a venue, if they'll have him holding 10,000 people, if that is workable for the venue and Mr. Williams' management, and he is going to donate all of the profits that he makes to a 501c3 charity. Mr. Williams wants to pledge $100,000 for the next 3 years to the Fulton County Sheriff's Office if they will hold an illegal firearm buybacks. Mr. Williams does not wish to go near the Cleveland Avenue area, not to insult that area at all, but it is just not a good idea under this circumstance. And he can drive on the highway, but otherwise not come within 1 mile of the area that we call Cleveland Avenue, and we can give the exact dimensions of that area. Mr. Williams must perform 100 hours of community service per year for the next 3 years as designated by probation department. Mr. Williams can associate, and this was agreed to previously, with people who are convicted felon or alleged gang members solely for lawful purpose of making music.
All right, I see Ms. Love shaking her head, and I think it's fair to establish that until the entirety of the negotiations were agreed to, it was all up in the air.
Sure.
That may have been something y'all had already hammered out, but it wasn't. It's not anything they're bound to.
Absolutely.
Fair. Okay.
I agree with that. Mr. Williams can have no contact with any of the supposed victims, and there was an Exhibit A attached to the state's proposed plea agreement, negotiated plea agreement that was sent to you, so we adopt that Exhibit A, but we can give it to the court if you need those names. And Mr. Williams have no contact with any of the co-defendants in this indictment, with the exception of Mr. Quantavious Greer, that is his biological brother, as well as Mr. Sergio Kitchens. He's a phenomenal artist. He goes performer known as Gunna, G-U-N-N-A. Mr. Williams and Mr. Kitchens are contractually obligated, and they frequently perform music together. Any other conditions that this honorable court deems appropriate? I want to thank the court for all your time. Always, I want to thank Ms. Percival for everything she has done. I want to thank Mr. Williams for allowing me to stand with him. I really never thought we would be here, but this is his decision. I want to thank the Honorable Keith Adams, who may want to speak, Your Honor, but I can never imagine a better lawyer than Keith Adams.
Mr. Adams, do you want to add anything to the record?
Your Honor, I don't know that there's really much to add. Mr. Steele has represented to the court, I think fully and thoroughly, the breadth of our knowledge of the case, Mr. Williams' background. I think the court has not just heard it from Mrs. Steele, but had the opportunity to sit here and hear some of the evidence and kind of get a feel. You've had a chance also to observe Mr. Williams and then get a feel for him, his background, and so forth. You know, the only thing I can say about Mr. Williams that hasn't been said is that he comes from, that there was an album, a concert tour. We came from nothing. And that is true. Mr. Williams came from, you know, I hate to use the word abject poverty, but that really is the case. Came from an area where there was a significant amount of crime, where, as you've heard, he's had tragedy in his life and has observed tragedy in his life, and he has gone through a good bit. He has been involved in a lot, but he has raised himself up. He has done the best he could and has done phenomenally well, and is, I think, an inspiration to a lot of people from that community who look to him and see the success that he has gained, and have been fully supportive of him. But he himself here, he is in front of you. He is tendering this plea because he accepts responsibility. You have heard everything Mr. Steele has had to say. I can only ask that you follow what we have put before you. You also have, I believe, the paperwork that was given to you by the state, which kind of gives you some idea of what they were looking for as well in terms of conditions on Mr. Williams if we were to have reached some sort of agreement. And we ask that if you feel that there is anything within the state's proposal that might be appropriate in terms of the sentence for Mr. Williams, that the court please feel free to do that. There is nothing that he puts himself before the court. And I think 2.5 years sitting, going through this process, challenging that you consider everything and sentence him appropriately in the way that we've requested. I'd simply ask you, I'd join Mr. Steele and Mr. Williams in asking you to do the same. And I thank you as well, as Mr. Steele did, for your patience with us and for bringing some order to the proceedings that candidly was needed. So that's all I have to say. I thank you again, and I ask you to consider everything that's been put before you.
All right, Mr. Williams, is there anything that you want to say?
Yes, ma'am. I take full responsibility for, my crimes or my charges. I want to say sorry to my family, my mom. My mom got 11 kids. I can't say her name. Really, everybody that got something to do with this situation, I want to say sorry for just having so much time invested into this, and I am a smart guy. I am a good guy, and I really got a good heart, I find myself in a lot of stuff because I was just nice or cool, and I understand that you can't be that way when you reach a certain height because it could be bad, and it don't really have to have nothing to do with you, but it could end bad, and it could, fall on you. And I know the choice is yours, it's up to you, and I hope that you allow me to go home today and just press in me to just do the right thing and never see you again unless it's at a bar in the future or something. Just out of this type of situation, I promise you I won't ever be in this type of situation again. I'm going away. I've learned from my mistakes. I come from nothing and I've made something and I didn't take full advantage of it. I'm sorry. Through these last 2.5 years of my life, you are really, truly, honestly, the best thing that has happened to me because you made everything fair for me and everybody involved on both sides, I'm sorry to the sheriff, everybody for just having to put extra time in. I know y'all got paid more money, but I'm sorry for y'all having to put this extra time in to be away from y'all family, and I just hope that you find it in your heart to allow me to go home and be with my family and just do better as a person. I know what I bring to the table. I know what I am. I know the heights I've reached. I know the impact I got on people, period, in the community, you know, all people. I learned that late, like these past 2 or 3 years of my life, I kind of learned that late. And maybe it was because I was, you know, probably on drugs or anything, I don't know. But I have came to my senses and I understand what I mean to this world. But I am a good guy, you know. I don't mind doing stuff like, you know, like free shows, and I always did that. You know, I did free shows and gave it to single parents, millions of dollars. You know, I made $1.8 million on a free show, and I gave it all to single parent charity. And I did like 2 or 3 shows that made like $700,000 a piece, and I gave it to the breast cancer organization. Like, you know, I do things. I put millions of dollars back into my community for real. I really did. I did more than anybody ever did from my side, you know. But I understand, you know, rap lyrics. I understand how it could be twisted. I understand what it could do to the mind of people. I understand all that, and I promise you I'm 100% changing that. You know, it's just, I'm older, I'm grown now, you know, and it's just like, I'm smarter. It's more things to rap about. Like, I've experienced a lot of good things. I experienced more bad things, but I experienced a lot of good things too. And anyway, I can go forever.
Well, I appreciate it. And I appreciate that you do realize how much of an impact you have on people. I mean, it's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around that, you know that gangs are damaging to our community. And it may be that a whole lot of rap music and the rap industry is, I mean, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television, where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap. But whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool, this is what I want to do. Look at him, he's a millionaire. I can do that by being, you know, a gangster in the streets. And that's not true. What you're likely to have happen, killed, or you get thrown in prison. And those are, you know, by far the most likely outcomes. And, you know, you've been in here watching the trial, and posing with a gun as big as he is and going out and shooting and killing another teenager. And that's what gangs do. And unfortunately, a lot of what rap music does. And if you are a modern day John Lennon, you know, I mean, he might have rapped too in this day and age. I don't know, but I know you're talented. And even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs. And, you know, I know that happens for protection sometimes, but a much better way would be getting an education and setting, you know, hanging around with people who's, I mean, all right, so that's my high horse on that. I could also go on. But I want you to try to be more of the solution, less of the problem. All right? All right, so it is not lost on the court that the state, had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, machine gun count. Was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be particularly worried that Mr. Williams on the streets would be a danger to society. I'm taking that into consideration in crafting my sentence. And in permitting a no-low plea to the RICO count in one of the two gang counts, to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts. And for the remaining counts with which you are charged, I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution. On count one, the court sentence is 20 years to serve 5 years, commuted to time served, the balance of 15 years to be probated, and a $25,000 fine. On count two, the sentence is 5 years to serve, commuted to time served. That's the minimum sentence that's permitted on that count. It is required to be run consecutively. I'm going to run it consecutive to count one, but I am going to backload. Oh, I'm sorry, that is not commuted. That is 5 years to serve, and it's going to be run consecutively to count one, backloaded, by which I mean after you serve your 15 years of probation. If you have been successful on that probation, and I sincerely hope that you are, then at the end of that 15 years, I will commute the entire rest of any service portion of your sentence to time served. So I'll get to the end of it and give you the total sentence, but I'm also going to impose a $15,000 fine with regard to that count. Count 57, 20 years to serve 5, commuted time served, the balance of 15 years probated, concurrent with count 1. Count 58, 10 years to serve 5, commuted to time served, balance probated, concurrent with count 1. 59, 5 years to serve, commuted to time served, concurrent with count 1. 60, 5 years to serve, commuted to time served, concurrent with count 1. Count 61, 5 years to serve, that is required to be also a consecutive sentence, so that's going to be run consecutively to count 56 and backloaded. Count 62, 10 years to serve, also required to be served consecutively, that's going to be consecutive to count 61, also backloaded. So essentially, the total sentence is 40 years to serve the first 5 years in prison, but commuted to the time that you have already served, followed by 15 years on probation, followed then by the backloaded 20 years, which can be served in custody and will be served in custody if you are not successful on your probation. If you are successful in completing your 15 years probation, that will be commuted to time served. You are to remain on reporting status for the first half of your probation, active reporting for the first 7.5 years of your probation, and that is pursuant to OCGA 17-10-1, subsection A 2A. And Mr. Steele and Mr. Adams, in order to keep him on reporting status, there needs to be good cause shown. We all concede that good cause is shown here?
Stipulate.
All right, I appreciate that. Special conditions of your probation.
What good cause? What do you mean?
Can I have a second, Your Honor?
Sure.
Let the judge. Thank you, Your Honor.
All right. You had enough time to talk with your attorneys?
Yes, sir.
Okay. All right, special conditions of your probation. After 48 hours from your release, you are to stay away from the metro Atlanta area, and that's defined by the U.S. Census Bureau. It may change, but you can look that up anytime to figure out what that is. For the first 10 years of your probation, subject to the following exceptions, you are permitted to be in the metro Atlanta area to attend any wedding, funeral, or graduation from high school, college, or graduate school of any of your immediate family members. And immediate family members is defined the same way that you all were contemplating it when you were negotiating. You need to leave within 48 hours after any such event. In addition, during each year of your probation, I'm going to require that you come to the metro Atlanta area and make a live anti-gang and anti-gun violence presentation 4 times a year, each year of your probation, at a grade school, a middle school, a boys or girls club, anything like that, that type of group. And if you want to, that presentation can include a benefit concert, and these presentations may count towards your required community service hours, which I'm going to impose, that during each year of your probation, you perform 100 hours of community service. You are, and this is required by the fact that there's a gang conviction. You shall not knowingly have contact of any kind or character with any other member or associate of any criminal street gang. Exception to that, if your brother is a member of any street gang, I hope you talk him into getting out of it. Contavious Greer, and then also Sergio Kitchens, as long as you are contractually obligated to him. That is going to include anybody who is named in this indictment, except as absolutely necessary to conduct the lawful business of your musical career, and to any extent that the state is not agreeing to the exception for Mr. Kitchens. In the event that that part is not enforceable because it is only a portion of a special condition, I'm going to provide that that be severable from the rest of this, and I'll put some case cites in the Senate sheet for that. You are in no way to promote any criminal street gang or any criminal street gang activity, including on any social media platform. You are not to utilize any hand signs, terminology, or language that promotes any criminal street gang. You are not to participate in any criminal street gang activity. You are not to knowingly engage in any contact with any of the victims that are listed in this indictment or with any of their family members. And you may not have in your possession or with arm's reach any kind of a firearm because you're going to be a convicted felon. And that is, except I know that you have security and you need security. You can be within arm's reach of a firearm that is in the possession of either licensed law enforcement or licensed security personnel that are in your security detail or anybody that you're performing with. You are to submit to random drug screens and not use any drugs unless they are prescribed for you by a licensed physician. You are to execute a Fourth Amendment waiver that will permit the search of your person, residence, vehicles, and electronics for any firearms, any criminal street gang paraphernalia, or any illicit drugs. And as I mentioned with regard to one of the first of your co-defendants from this trial, at least since I've been involved, to plead guilty. Our Uniform Superior Court rules instruct and provide that it is absolutely proper for a judge to grant leniency in sentencing when, quote, the interests of the public and the effective administration of criminal justice are served, unquote. And I think that this plea is in the interest of the public and in the interest of effective administration of justice. Have been trying to ensure that, to the extent I can, this trial also abides by that. It's been challenging at certain times. I find your plea to be freely, knowingly, intelligently, and voluntarily entered with an understanding of the consequences, and I accept it as such. I also need to inform you that your attorneys were going to represent you through either the last day of this term court or 30 days from now, whichever is later, and any of the filings that were mentioned that need to be filed within that time, they would file on your behalf unless they are permitted to withdraw from representing you before that time. I am not going to impose the conditions suggested by your counsel about the benefit concerts and the donations to the sheriff's office, but I certainly strongly encourage you to do those things. And to do and continue to do things that benefit your community and especially help young people to stay out of criminal trouble. And unless there is anything from counsel other than that.
I have one matter, Your Honor.
Okay, and does the state as well?
Your Honor, with regards to Mr. Williams being permitted to come to the Metro Atlanta area or Cleveland Avenue area for a funeral or the other items,
Right.
can you also consider, God forbid, there's a serious medical condition of a person?
In his immediate family, certainly, we can add that. And I also meant to mention, because I know you do travel all over in order to pursue your career, that it's permissible for your probation to be transferred to out of state, and that has to be done through probation, but that is fine with the court. And you may also keep your, nobody's mentioned it, but keep your passport and travel out of state and internationally to the extent that you need to do that for business purposes as well. All right, Mr. Body.
Yes, just very briefly. Thank you. The district attorney just wanted me to urge the court, due to the fact that the Thomases have been negatively affected incredibly traumatically by what has been discussed by both parties here today, to make a brief statement as she believes that they fall within the exception or within the bounds of Marcy's law. If the court would allow, I understand the court made a ruling earlier as it relates to that, but she wants to.
All right. Thank you. And I appreciate, well, I cannot even begin to understand what they must, anybody must be going through when they lose a family member to violence or criminal violence. Mr. Williams himself has expressed his own sorrow to the family. I, again, am going to stand by my belief that the appropriate time to hear a victim impact statement from them is at the close of the trial that contains the murder count with regard to their family member. All right, thank you. Okay, court is adjourned. Good luck to you. And there better be no violations, but if there are any, you're coming back to see me. Yeah. All right.
Thank you, Your Honor.
There you go.
But since the
Let's take a recess, and I'll be back. trial. So I know that go forward and say, well, we're not skipping the rest. I'd like to charge Mr. Forward.
3, which 2, 1, so 59 was the code, which is the possession years. Controlled Substance Act, that is for the year. Which was count 6, as to count 59, I believe that's the possession of codeine with the intent to distribute, which is 1 to 5, which is 5 to 30 years, and count 59, which is the possession of cocaine, which is
60 is possession of cocaine.
so 59 was the codeine, 60
Right.
is the possession of cocaine, which was 1 to 5 years. Possession of a firearm during the commission of a felony, which was count 61, which is 5 years to serve consecutive to any count indictment. Possession of a machine gun, which was count 62, which was 10 years to serve consecutive. And then he was charged with count 63, which is possession of a firearm by a convicted felon pursuant to 1611-133. I know my math isn't the best, but that's life plus a couple, some years. The state's recommendation, Your Honor, was for Mr. Kendrick to plead to count 1, conspiracy to violate the Racketeer Influence and Corrupt Organizations Act, which was 20 to serve 15. Count 2, the murder reduced to voluntary manslaughter, 20 years to serve 15, 20 years to serve 15. And then to the gang count 57, also 20 years to serve 15, all to run concurrent, and the state was willing to null pros all the other counts in the indictment.
All right. And Mr. Kendrick and the attorneys associated with you, I want to make sure that y'all know that unlike what happened with Mr. Williams, if you plead non-negotiated to less than all of the charges, there is nothing that the court can do if the state chooses to go forward with some of those charges. So you couldn't do what Mr. Williams pled guilty or nolo to each of the charges that he was facing. You cannot say, well, I'd like to plead guilty to count 1 and I'd like to plead to the reduced charge on count 2, and then I'd like to just skip the rest of them, because the state can say, well, we're not skipping the rest of them, we're still going to try you for the rest of them. And the state can also say, we're not okay with letting you plead to voluntary manslaughter unless you abide by the terms of the agreement. We're going to go forward with the murder trial. So I know that Mr. Weinstein, you and Mr. Apt and everybody else who's been helping know that, but because things seem to have worked out sort of beneficially for some of these other people who have already pled, y'all might think, oh, well, gosh, can't we do something better than that? Given what you're facing, they hold a lot of the cards, and a lot of it is outside of the ability of this court to change. Okay? All right.
We understand that, Your Honor. Thank you for advising us of that.
All right. Mr. Stillwell is facing.
Your Honor, Mr. Stillwell is also looking at count 1, which the conspiracy to violate the Record Influence and Corrupt Organizations Act, which is 5 to 20 years. He is facing 2 counts of murder for count 2 and count 49, which each carries a sentence of life imprisonment. He's also charged with count 50 of the indictment, Your Honor, which is participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He's also charged with count 51, participation in criminal street gang activity, also a sentence of 5 to 20 years. Count 52, possession of a firearm by convicted felon, previously convicted under 1611-133, which is 15 years consecutive to any count in the indictment. 54, possession of a firearm during the commission of a felony, which is 5 years to serve consecutive. Count 64, which is another possession of a firearm by a convicted felon under 1611-133, which is also 15 years to serve consecutive. So Mr. Stillwell's looking at maximum of 2 life sentences plus
85 years.
Plus 85 years, Your Honor. The state's recommendation, and I'll just say globally, Your Honor, was 60 years to serve 40 years in prison, that we would have reduced both of the murders to voluntary manslaughter, Your Honor. And we had given his attorney the option to kind of craft how that 40 years would look, but that was the extent to our negotiations, Your Honor.
And Mr. Stillwell, kind of the same information to you. If the state does not want to reduce charges, you're not entitled to plead to reduce charges. They can say, you got to face these murder charges and we're going to make it a jury trial if you don't agree to what we're offering. Same thing, you can't say, well, I'd like these other charges dismissed if they're not willing to dismiss them in exchange for the negotiated sentence. So obviously each of you has the right to continue with the trial. You know, you are all have very capable attorneys representing you who clearly care very passionately about you all personally, as well as presenting your best case. But it's ultimately going to be up to the jury, and you cannot know what any jury is going to do. And they may say, I don't believe a single bit of this beyond a reasonable doubt. Y'all are both welcome. They may say, you know what, I buy this, I don't buy that. I'm still then going to face sentencing. They may convict you of everything. And if you are convicted of everything, Mr. Stillwell, you're facing 2 life sentences plus 85 years on top of that, as opposed to 40 years to serve with parole as a possibility. And Mr. Kendrick, you are facing life plus, I think I added up 115 years instead of 20 to serve 15. So it's just something to think about. And I mean, it's already past 5 o'clock. So are y'all going to leave the offer open until you have withdrawn the offer before you even put it on the record to?
We communicated this to them last night, but they did not accept it. That we would have withdrawn off.
All right, well, given that the state spent the entire day negotiating Mr. Williams' plea, ultimately unsuccessfully, I don't know if either Mr. Weinstein or Mr. Sharp would have been able to negotiate with you during today.
They would have, no one, we didn't have any communication from Mr. Weinstein or Mr. And they rejected the offer.
Okay.
I did have communication with Mr. Abate today. I attempted to have
All right.
communications with the DA last Tuesday
Well,
morning, but she failed to show up for our meeting.
Any chance y'all might leave it open until 9 o'clock tomorrow?
Your Honor, I'll consult with the DA and if she wishes to read.
Okay. I mean, I have no idea whether they'd want to keep it, but I haven't, we haven't put it on the record, and I haven't ensured myself as the court that they understood what the potential sentences were up until just now. So I would appreciate it if she would, so that they have the opportunity, having heard from the court, to talk to their attorneys. And they may still say that we're good, we're going forward, but.
We'll consult with the district attorney, but as a.
Okay. So in the event that it is no longer open to you or that you decide to reject it anyway, I plan to start the trial again Monday morning. I'm going to have the jury be here at 9. I'm going to have us be here at 8:30. So y'all at 8:30 regardless. Okay, now court is adjourned.